Does getting shot by the police constitute a seizure under the Fourth Amendment? To find out, you have to read Torres v. Madrid, but it's 47 pages. Don't have time for that? I've got you covered. Today we delve into the intriguing case of Torres v. Madrid, where the Supreme Court grappled with this question. Is a person seized under the Fourth Amendment even if they escape after a police officer uses physical force intended to restrain them? This question was at the heart of the Supreme Court case, Torres v. Madrid. To understand the case of Torres v. Madrid, we need to understand a little bit about the Fourth Amendment. The Fourth Amendment to the United States Constitution guards against unreasonable searches and seizures. It's a fundamental safeguard of our privacy rights and personal freedoms. But what exactly does a seizure mean in a legal context? Historically, courts have viewed a seizure as occurring when there's a physical touch with intent to restrain, or a show of authority that restricts freedom of movement. But the boundaries of this definition have been tested over time, leading to a collection of legal precedents. One such significant precedent is the case of California v. Hodari D. In this case, the Supreme Court ruled that a seizure does not occur until a person is physically touched by an officer or submits to an officer's show of authority. Now, the Torres v. Madrid case asked the Supreme Court to consider a nuance. Is it a seizure if the police apply physical force with intent to restrain, but do not succeed in subduing the person? That's the question that lies at the heart of the case. The other background to understand is that a person can file a lawsuit for money under 42 U.S.C. 1983 when they claim that a state actor has violated their constitutional rights under the color of law. With the Fourth Amendment in mind, let's now turn to the facts of Torres v. Madrid. The facts of Torres v. Madrid began in the early morning hours of July 15, 2014. On this fateful day, Roxanne Torres found herself in a New Mexico apartment complex car park, where she encountered two police officers, Janice Madrid and Richard Williamson. Not realizing they were officers due to their plain clothes and unmarked vehicle, Torres decided to make a hasty exit in her Toyota FJ Cruiser. The officers, believing that Torres was a suspect they were looking for, moved to intercept her. In the ensuing chaos, both officers discharged their firearms, striking Torres twice in the back. Despite her injuries, Torres managed to drive away, embarking on a 75-mile journey to a hospital in Grants, New Mexico. It's important to note that Torres was not the suspect the officers were initially looking for. The officers had mistaken her for another individual due to a case of mistaken identity. This error, coupled with the excessive use of force, formed the crux of the legal contention that followed. Torres's escape set the stage for a legal battle that would reach the highest court in the land. After the shooting incident, Torres brought a 42 U.S.C. 1983 civil rights lawsuit against the officers. She claimed they used excessive force in violation of the Fourth Amendment. The district court, however, saw things differently. They ruled in favor of the officers, agreeing with their argument that no seizure had occurred since Torres had managed to evade capture. Without a seizure, there was no constitutional violation. The case didn't stop there. Torres appealed to the 10th Circuit, but the outcome remained the same. The 10th Circuit upheld the district court's ruling, agreeing that no seizure had taken place because Torres was not successfully restrained. But Torres wasn't ready to back down. She took her case to the highest court in the land, the Supreme Court. The justices agreed to consider her case, intrigued by the novel issue it presented. This decision marked a turning point in Torres's legal journey, allowing her case to be heard on a national stage. With that, the stage was set for the Supreme Court to make its ruling. In a 5-3 decision, the Supreme Court ruled in favor of Torres. The majority opinion, penned by Chief Justice John Roberts, stated that an individual is seized under the Fourth Amendment the instant an officer applies physical force with the intent to restrain that person, irrespective of whether they manage to escape. This ruling fundamentally redefines the interpretation of a seizure, emphasizing the officer's intent and the application of physical force, rather than the successful restraint of the individual. However, the decision was not unanimous. The dissenting opinion, which held sway with 3 justices, argued that a seizure requires successful restraint. They contended that the majority's definition was too broad and could potentially lead to unforeseen consequences in future applications of the Fourth Amendment. The Supreme Court's decision in Torres v. Madrid marked a significant development in Fourth Amendment jurisprudence. The impact of Torres v. Madrid extends beyond the parties involved. The ruling has implications for future Fourth Amendment cases, potentially altering the landscape of civil rights litigation. By refusing to create a new loophole for police shootings, the Supreme Court has sent a clear message. The application of physical force with intent to restrain constitutes a seizure, even if the force doesn't succeed in subduing the person. This could mean that victims of police violence have broader recourse for seeking justice. Additionally, this ruling could have a ripple effect on police conduct, potentially prompting law enforcement agencies to reassess their use of force guidelines. But the ruling is narrow. It doesn't address other police armaments or the reasonableness of the seizure. The lower courts will be left to determine these aspects. While the full impact of Torres v. Madrid is yet to be seen, the case serves as a critical reminder of the ongoing debate over the boundaries of police authority under the Fourth Amendment.
If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.